Calling our second case of the day, Grady versus Wambach. This is a 20-minute grant. We'll wait just a minute.
I am expecting to be opposed. Shall I begin? No.
No.
Grady? Grady? Grady?
Grady v. Wambach.
Yes.
Mercyland? Mercyland. I'm sorry. That's right. I apologize. Too many times. Been saying that for years. Good morning, Your Honors. Drew Broadus for the defendant, appellant, Mimic. I'll waive the free fire, but as the court will recall, the leave was granted to address whether the insurance company has statutory standing to challenge whether the members and managers of a healthcare provider incorporated as a PLLC are properly licensed as required by the Michigan Limited Liability Act. And if we set aside Miller for the sake of discussion right now, this seems like an easy question because the No Fault Act requires carriers to adjust claims to ensure that they're payable under the Act. And under 500.3157, services have to be lawfully rendered in order to be payable. So that would seem to me to confer statutory standing to at least question this issue. It doesn't mean every corporate defect renders a service unlawful, but it means we should at least be able to dive into the issue, which Miller says we can't. If corporations seeking the payment, and as the MDTC alluded to in its amicus brief, I guess that may be getting ahead of myself, but with the rise of provider litigation, that this is a bigger deal now than it was when the act was created. But if the corporation is the entity seeking payment, it stands to reason that they need to be properly organized to be lawfully rendering their service. After all, they're getting the benefits of incorporation, limited liability. But Miller says that although we're required by statute to adjust the bills, we're barred from even getting into it. It's a jurisdictional bar. It's important to emphasize when the Miller court talks about this, the statutory standing means the court doesn't even have jurisdiction to entertain this type of challenge, which I think is a big problem. Now I'll get into what we do about that. I think there's three paths to deal with Miller that all lead to where I'd like the court to go, which is to reverse the Court of Appeals and reinstate the trial court ruling. The first, I think Miller was wrongly decided. The court, I think, conflated the challenge to the corporate form that is delegated exclusively to the Attorney General with defenses to payment. When a no-fault carrier is not trying to dissolve these corporations, they're not trying to assess some kind of penalty for their errors or their oversights in formation. Simply saying that we're simply trying to enforce what 3157 says, that we're not obligated to pay if you're not lawfully rendering the service. So I think that court missed the mark a bit on what these sort of challenges actually are. And clearly we have standing under the No Fault Act to ask. I mean, no one's ever challenged whether we can raise the licensing issue, which is another I'll get into in a moment. So there's this, under Miller, there's this broad category of lawfulness that we just can't inquire into. It's a jurisdictional bar, as I noted, but we can be compelled to pay. And if you carry Miller to its logical conclusion, the first issue I have with Miller is statutory standing is almost always associated with the capacity to bring a claim, not a defense to a claim. I know there's certain situations where it applies, but the broad problem with Miller. And then if you carry Miller all the way to its logical conclusion, do we even have corporate veil piercing anymore? Because do you have standing to say, well, this corporation hasn't been, it's been used as a mere, a shell, they filed the corporate form. I think you could read Miller to say that's no longer on the table. No one's taken that position yet, but there's no reason you couldn't, the way I'm reading Miller, at least as it's been applied since. The second path, Miller didn't survive a Lansing Board of Education in 2010. We got a new statutory standing analysis. There is an unpublished case I've cited Zygmunt Chiropractic, it's from the Court of Appeals from 2013, that really lays this out. I know it may be odd to cite a non-binding case that even lower courts aren't obligated to follow, that everyone seems to have forgotten about from 10 years ago, but I think if you look at that opinion, it's not particularly long. It really lays out a logical analysis of how, after Lansing Board of Education, the statutory standing inquiry should work. And that's in my appendix to the copy of the opinion 152A. And then the third route would be that it's simply distinguishable. We have standing because the challenge in this case is fundamentally a challenge to licensing, not under the Corporation Act, but under the Public Health Code. And the subpart that purportedly deprives us of standing, it refers to the Act, and the Act in that context is not, it's a Limited Liability Corporation Act, not the Public Health Code. Justice Sawyer's dissent in this case lays out that analysis, and if the court were inclined to go that route to preserve some form of Miller and still affirm what the trial court did, I think that would be an easy target. I know in the past, prior courts have affirmed for the reasons stated by the Court of Appeals dissent. That might be one possibility if the court's interested in avoiding whether Miller was rightly decided or survived Lansing Board of Education. But I think it's the right time to look at Miller and address whether it's still viable, and I don't think it is.
If we rule in your favor, do we have to overrule Sterling Heights?
I think so. I thought about that. Now, Judge Sawyer's dissent, he took the tack that I agree with. Sterling Heights didn't really deal with this issue. It should have, actually, that was there. For whatever reason, the parties either didn't brief it, or it's hard to say why. But if you look at Judge Sawyer kind of just said this is an issue. I'm paraphrasing, but it's not controlled by Miller. It wasn't addressed in Sterling Heights. So, but if you go with one or two and you say Miller's no longer viable, then I think Sterling Heights just has to fall because it really just followed Miller. I don't think there's a whole lot of independent analysis there other than they look to a different subpart of a different act, a corporate act, but it's the same reasoning. So I guess what I'm saying is probably yes.
Can I ask just as a practical matter, like let's say we agree with you, what's the effect on a patient, right? Like that they're seeking care from a physician or from an entity, and somehow wouldn't they now be obligated, if we agree with your position, to somehow not only understand how the corporation was formed at the beginning, but keep up with the sort of licensure and all the statutory requirements of the corporation itself? I mean, I don't know how any patient is supposed to
So their concern would be
figure that out.
if it's not compensable under no fault, then these entities could come back on the patient.
Sure.
And if them,
Right,
that's
I mean, and as a practical matter, I mean, they're seeking out, I mean, maybe it's even a question of whether or not they actually, your typical patient makes sure that their doctor that they're receiving care from is properly licensed.
Right.
That's a little bit easier of a reach, but like to reach then into the formation of the corporate structure that the patient then needs to know how that was formed and who was licensed where, and does it have to be in the state, or how that, I mean, what's the practical real world effect on patients receiving care and then being found to be not compensated?
That's a good question, and my answer is twofold. First, there's not going to be a completely satisfying answer for all scenarios, but we are dealing with statutory construction, and only lawfully rendered services are compensable. So I could imagine situations where that's a problem for patients, but I would also add, well, for one, hopefully, if this opinion may prompt some of these entities to sort of clean house and get their act together and figure out, in this case, it seems to be a particularly egregious situation. You had someone not licensed in Michigan at all who was a sole member and organizer, for example. I mean, hopefully, if word gets out, this problem isn't going to go away completely, but we'll see less of it.
Wouldn't the word get out by the AG actually taking on that issue as opposed to mimic in this one particular case?
Well, it would certainly help, but I mean, that's really what Miller said, is that the AG is the only entity that's authorized to raise these challenges. But the problem, again, is the no-fault carriers are on the hook to pay this, and there's a lot more no-fault carriers dealing with the issue than the AG. There's a relatively small office They can't be everywhere. Apparently, in this particular case, there's no indication that the AG took interest in it. But the second part of my answer is also, every defect in the corporate formation is not going to render the service unlawful. And the problem we're at now is we can't even ask the question. But you could imagine scenarios where somebody, say a chiropractor, fully licensed chiropractor, forms a PC for the limited liability protection and then forms it under the wrong act. Is it unlawful to be a chiropractor? No, you don't have to be incorporated. You can just hang up a shingle and do chiropractic. I don't know that that would result in the being rendering unlawful, but my point is, under Miller, that whole inquiry is just closed.
Are there criminal penalties and potential sources of restitution for the unlicensed practice of medicine?
I'm sure there are.
Yeah. Are there similar laws in place for the failure to have licensed members under the Michigan Limited Liability Company Act?
I don't believe there are.
I don't believe there are. So what do we make of that?
Well, the No-Fault Act doesn't say it's got to be criminally sanctionable. It says it's got to be lawful. And I'll point to the Amger article, which talks about this a little bit. Actually, it's not binding, but that a lawfully rendered requirement, implies compliance with administrative rules, with corporate formation rules. So I see your point, and it kind of goes back to Miller, that there's a body to deal with these violations. The question, I think, that where Miller got that wrong is, why do we not get to even ask the question when we're being compelled to pay under another statute? See, so if the issue is statutory standing, I guess the question is what statute? The No-Fault Act clearly says we're supposed to adjust these for lawfulness, not criminality necessarily, but lawfulness. If there's no other questions at this time, I'd like to make a couple small points and then reserve what's left for rebuttal. These are just miscellaneous arguments I'd like to address up front. Plaintiff argues that they are actually lawfully rendering the service. Again, the Court of Appeals said we can't even get into that question, but assuming we can, the subpart they're relying on is 450.4904, subpart 5. As I put in my brief, it doesn't apply to corporations governed by the Public Health Code. It's got to be read in conjunction with the other subparts. Basically, subpart 2 says except as provided in 3 or 4, not 5, doesn't refer to 5. So there's an independent requirement in 49042. And then there's, again, that would really be an argument against the leave grant. There wouldn't be a whole lot of point in dealing with the statutory standing issue if there was this other issue out there that sinks the whole case. That's all I have for now.
What happens if a patient receives health services from a PLLC and during the course of the treatment, the member or the shareholder's license expires? Do the healthcare services at that point become unlawful?
So they
start and everybody's fully licensed, and then they fail to renew a license, or somehow it's terminated. Does that then make whatever they were receiving on day when they have the license, it's lawful, and then
Right.
the day they don't have the license, it becomes unlawful?
Well, if the services were provided when the license was still in effect, I would submit that that's not an issue under 3157 because it's lawfully rendered. So the operative event there is when it's rendered, not necessarily when they go to the courthouse and try to get paid. So,
Can't hear you. You might want to move the podium up a little bit for you, because I went to too many Rolling Stone concerts when I was younger, and I have a hard time hearing.
I
There's a
didn't
way
know
to
it was adjustable.
put it up. You either speak up or there's a button underneath that'll put it up so that we pick up your voice a little bit better.
I may just lean over because, is this better?
That's better.
Yeah.
There's a little switch there that you press and it goes up on the side,
Okay.
in front of it.
Well, now I'm down to 6.5 minutes, so I think I'll just lean. So I would submit if the scenario is they're treated by a licensed professional and then they lose their license at some point after the treatment before they seek compensation, I don't know that we have a defense under 3157 because of the phrase.
No, but they go Monday, Wednesday, and Friday. On Monday, Wednesday, they're licensed, but on Thursday, the license, they didn't pay the fee, it didn't get renewed, therefore it's expired. Does that mean you'll cover Monday and Wednesday under the act, but Friday they don't get coverage?
Well, the operative act is rendered when it's rendered. So
So under the No Fault Act, they expect people who are receiving treatment, before you go in, you better call, it used to be the Michigan Corporation Division, now it's licensing and some other division. You have to call every week just to make sure everybody's still licensed?
If that's,
Can I clarify? I think
Yeah, go
you're not saying that the person providing treatment loses their license.
No,
You're
the
saying the
owners.
corporate,
The corporate.
the owner.
so it's the situation like this where it's the only member and the only manager. It's a sole, because if you have an organization, all right, there's a statute requires every member. Here's what I'm trying to get at. It's got to be every member and manager. This is like an employee that's also
No,
a licensed professional.
one of the members that,
Right,
one of the
loses their
members of the
license.
PLC doesn't comply with the Michigan Limited Liability Company Act, and they were supposed to renew, and they didn't. Does that all of a sudden, does that mean that they, on Monday and Wednesday, when they had the license, we'll pay for it? But on Friday, they didn't have the license, therefore it became unlawful. Bad on you. You should have called Lansing to make sure they had the license before you went in.
I can say maybe an issue, but we're at a disadvantage here as an industry in terms of answering that, because since 2007, we've been told can't even get into it. So there's no developed body of case law at any level, Court of Appeals or otherwise, even unpublished law dealing with this. It's pretty much just been a no-go zone in terms of these sort of issues. So I don't have a satisfactory answer to that. I can't say that this wouldn't result in certain situations where a patient has got a problem. And I would submit too, if it's not compensable under the statute, and that provider is going after the patient directly, that provider may have a problem. The patient may be able to assert this as well, that, you're coming after me, as an entity that isn't properly formed, or isn't properly maintained its license. There may be defense to payment from both the carrier and the patient. But there isn't the case law out there because of the fact that what Miller has told us.
Thank you.
Is that all for now? Okay. Thank you. Looks like I have about 3.5 minutes.
Good morning. Paul Valentino, appearing on behalf of Mercyland. It's interesting listening to the dialogue. The PLLC does not require any licensure, period. The individuals who may be members need a license. Section 5 of the statute provides that foreign licensed professionals can be members. They just can't practice. There is no exception under the Public Health Code in Section 5. And it's interesting that listening to, if you follow what the appellant wants you to do, then what you wind up with is this situation where you've got, is any PLLC properly licensed if one of its members loses a license? The answer to that is no, because there's a distinction. The entity in and of itself needs no licensure requirement. So what happens to a member doesn't affect the validity of the PLLC. Once and that goes back to once it's formed, the only entity that can deal with taking that entity's formation away is the Attorney General. It's presumed to be validly set up, validly incorporated, or validly organized. That distinction is important because unless the legislature says a PLLC needs to have its own license, there's no way for any consumer who's out there seeking medical care is ever going to find out whether that's validly incorporated or validly organized. The people in this case that provided the care were all licensed in the state of Michigan. That is without exception, and that is not disputed.
Counsel, even if I were to agree with you, sort of on the underlying merits of the claim, I mean, how do you respond to MEMIC's claim that they just want the opportunity to make the argument in the lower courts? That they have standing?
The legislature says that they don't have standing. The Attorney General is the only, it's presumed to be validly enacted, and the only one that has standing to challenge that is the Attorney General. That's what the legislature, that's a legislative decision. That's what they've decided in this case. That's why it doesn't matter what MEMIC or anyone else thinks about a corporate structure. We'll be fighting corporate structure issues and delving into whether there's some technical difficulty or technical problem with the incorporation, whether they've actually acted as a corporation, whether they had annual meetings, whether they filed minutes, whether they voted on who they elected as officers. All that stuff will then come into play, because if none of those corporate requirements or PLLC requirements are met, then is it validly existing? I would say no. All
So
those
you find
issues-
this case is indistinguishable from Miller? They're
Right, it's
the
not
same?
distinguishable. The PLLC does not require a license, and the individual that was that created it, Dr. Abraham, is a foreign licensed doctor. He signed the attestation on the annual reports indicating that he understands that he's a foreign licensed doctor and he can't practice in Michigan. He provided no services. The individuals that were providing services were licensed, so it's on all fours with Miller. There's no issue with respect to what occurred in this situation, and the standing issue is legislative. The legislature said under the statute, it's presumed to be lawful once it's accepted by the state. And the only one that can attack that is the Attorney General, and that makes the most sense, because otherwise we'll have unwieldy litigation, and again, the fallout's going to be on the individual who purchased a contract of insurance, gets in an accident, goes to a doctor, and now all of a sudden, he's got to defend whether this corporation or this PLLC was lawfully created or is lawful at the time the services were rendered. That's an unfair burden on the consumer, and again, it's another technical issue that an insurance company is simply saying, we took our premium, we don't want to pay. So how can we get out of pay? Yeah, the doctor that provided the service was licensed in the state of Michigan, but maybe we can say that the PLLC, that is simply an organization he worked under, had some technical problem. Therefore, we can avoid paying and stick our customer with the bill again. And that's unfair, and it's unreasonable, and it puts an unfair burden on the consumer and on the injured person to have to try to go out and figure all this out, or hire a lawyer to figure all this out, simply to get treated.
I know this isn't really the issue in the case, but what do you make of Mr. Broadus' answer or suggestion that the injured, or that the insured, the patient, would have the same or similar defense
I don't
against
think
the
that-
provider?
I apologize.
No.
I don't think that they would. If you've got a licensed physician who provided care and is seeking to be paid, I think that they're going to come back and say, he was licensed, the service was rendered, you agreed to pay it.
A different analysis, right?
Correct.
Okay.
And again, it's going to open a whole panoply of litigation again for the consumer who bought the insurance policy, who got in an accident, now has to hire lawyers to fight this battle and protect themselves from litigation, being sued to get the bills paid because their insurance company, who's supposed to pay the bill, got out on a technicality because they can now challenge whether a PLLC or a corporation was lawfully incorporated, or at the time of services was lawfully incorporated, whether it followed all the formal requirements for a PLLC or for a corporation. And if it didn't, then it's not lawful. Then even though the doctor's licensed, we don't have to pay. And that's just an unfair burden on the consumer, on the person that's injured. And I think the standing argument makes the most sense. I think that the way it's set up, the statutory requirement, makes perfect sense. And I don't believe that they can demonstrate any basis to get around what the legislature has determined in terms of it being presumptively valid once it's been accepted by the state.
Let me ask you a question about that. Miller focused on the analogous act language in the Corporations Act. that said filings conclusive evidence that all conditions precedent required to be performed have been fulfilled, et cetera. And the same language, of course, appears in the Limited Liability Company Act, in section 90, let's see if I have it right, section, I'm sorry, 202, 450.4202. But the requirement here that's at issue, and putting aside the unfairness, and I'm not unsympathetic to your points, but it talks about, the requirement is that if a PLLC performs or renders a professional service under the Public Health Code, then all members and managers must be licensed or legally authorized to render the same professional service. That would seem like an ongoing requirement, not a condition precedent. Isn't that a problem for your argument that Miller simply applies? I mean, are those, how can we think of those, of an ongoing requirement as a condition precedent?
With respect to that issue, first, I take exception to the position that that's required. That section 2 talks about, under the Public Health Code, everybody has to have the same license. And then if you look at 3, with the exception of section 3 and section 4. Section 3 and section 4 permit different types of licensure, a surgeon and a podiatrist. It specifically identifies what that actually is saying is, under the Public Health Code, if you're licensed, everybody has to be a pediatrician. Everybody has to be a gynecologist. Everybody has to be the same.
Not everybody, all the members and managers, right? Not everybody.
Pardon? I'm sorry.
Not everybody, just all the managers and members.
Right, no, that's what I'm just saying. They all have to be the same specialty or have the same license, with the exception of 3 and 4, which is, I think, a podiatrist and a surgeon, or
I agree with you, chiropractors.
okay, so that's what it's really addressing. It's not intended to say that if it's a public health code, everybody has to be licensed in Michigan, because that would negate section 5. And they easily put in the language in section 2 addressing the public health code. Section 5 doesn't address that. Why would they, if they wanted it to be a requirement for all licensed persons in the public health code to be licensed in the state of Michigan, why wouldn't they in section 5 have said, except for the public health code, everyone else, every other type of licensed expert or a licensed person can be a foreign licensed person and be a member or manager, but they can't practice in the state of Michigan. The fact that they didn't include that, and the fact that on the attestation on the annual report simply has a provision to indicate that you understand that if you're foreign licensed, that you can't practice your specialty in your field in the state of Michigan, it doesn't, again, exempt public health officials. It's a general attestation. The whole thing is set up to allow foreign licensed persons, including medical persons, to be members and managers, but they can't practice until they get licensed in the state.
I don't know if the whole thing is set up that way, but that certainly seems like the import of subsection 5. And I do find it to be confusing trying to reconcile all this, but is one way of thinking about it that the subsection 5 is set up to allow a doctor licensed in a different state to set up an LLC and apply for licensure here, but the PLLC can't begin to operate until the doctor obtains the appropriate license?
No, I think that it's set up so that he can do that, hire licensed practitioners in the state, and they can provide the services. He can't until such time as he becomes licensed. Then he also can provide the services, which is what occurred in this case. So, and again, that all begs the question, because you can't, I don't think you can delve into that if it's presumptively properly created because the state has blessed it. If it's an ongoing requirement like you're suggesting, He was not licensed in Michigan when he created it. It was presumed to be valid at that time, and the only person that can attack that is the Attorney General. I don't think that changes throughout its life. The Attorney General can at any time come in and say, wait a minute, you cannot, this is not lawfully created.
Yeah, there appears to be some tension with the notion that the PLLC renders the service instead of the individual members and managers, right? That's where the tension comes into place. But I think it's hard to deny that the requirement, the licensure requirement's an ongoing obligation. Because it says if it renders a service, that would presumably, if it hasn't started rendering the service, then they don't have to yet be licensed. You know,
Right,
that
but if it's-
implies you could set it up and not start operating until the licenses are obtained, I think.
I don't think that it provides that at all, Your Honor, simply because it doesn't say that, and it says that you can have a non-licensed member who's a licensed professional in a foreign jurisdiction, and all it says is you can't practice until you're licensed. It doesn't say the PLLC can't engage in practice. It doesn't, and if they intended the PLLC not to be able to engage in medical or any other practice until that individual member is licensed, that's what it needs to say. It doesn't say that. It singles out the one individual or multiple individuals that are not licensed in the state and says, you agree that you can't conduct any professional services until you're licensed in the state. That's what it says. It doesn't say the PLLC. It simply says that member or that manager.
Yeah, I get it, and unfortunately, it doesn't say enough to on either side, but I understand your argument. I think it's good that you're raising that point, or emphasizing it.
And I think with respect to the standing issue, I think that Miller was correct. The people involved in this case that provided the service were licensed, and the PLLC has no licensure requirement. So peeling back the onion, if you will, and saying, well, someone who is a member can't practice because he didn't have or she didn't have a license, that begs the question. The PLLC is lawfully created. Those rendering services were licensed in Michigan. That's all that is required. If the legislature wanted it different, they could have said the PLLC has to obtain a license. They didn't say that. So the PLLC, once lawfully created, the people under it providing the services are providing lawful services based upon their license. There's no requirement for a license by a PLLC. The Miller decision is sound. It pertains to the issues in this case, and that's what should be followed. And if there are any other questions? All right, thank you very much. I appreciate it.
Thank you.
If there are professionals that were fully licensed and rendered these services and entitled to payment, then let them be the plaintiff. The issue here is we have the corporate plaintiffs that get the benefits of incorporation and aren't complying with the requirements. Now,
What about counsel's argument that he did comply with the requirements because of subsection 5? What's your response to that?
subsection 5 doesn't apply when you're controlled by subsection 2, if you're rendering a professional services that included within the public health code. And this is talked about at pages 18, 19 of my principal brief. When you look at 5 itself, it doesn't talk about, it just says a licensed person or of another jurisdiction may become a member, manager, employee. It doesn't talk anything about physicians, any kind of medical professionals at all.
So your position, let me state it a little more precisely. Your position is that since subsection 2 doesn't say except as provided in subsection 3, 4, or 5,
That's part of
that
it.
5 doesn't come into play?
Right. Because you've got the specific governs the general, and you have a specific subpart here in 2 that talks about if you're regulated by the public health code. 5 is the general provision, just talks about professionals under this act generally, no reference to public health code. And then 2 and 3, the carve-outs specifically address different parts of the public health code. And the interesting about this is it all goes to the merits, whether the trial court got it right, which Miller says we can't talk about. So that, I think, is the overarching problem of all this, is there's this jurisdictional bar under, at least as the Court of Appeals construed Miller, to even getting into this. We didn't even reach the issue for that reason. I think that's a big problem with this. And the underlying theme here of counsel's argument was, you know, that we can't let insurers jerk people around with technical violations of the various corporate acts, but there's
Is there a
already
way for a patient to know if all the members and managers of a PLLC are licensed?
Is it,
And then,
well,
and more specifically, is there a way for a member, so for a person to know who all the members and managers of a PLLC are?
it's theoretically possible with some investigation. I'm not suggesting every patient would have to do that, but
What does that mean, some investigation, like you
Well,
hire
it's
a
all-
private investigator?
no, you pull their documents off the Secretary of State if it was really an
What's
issue.
on that, what's on the Secretary of State's website? Does it have, I don't recall a listing of all the members and managers being required as part of your filing. Don't you just have to put your, what, corporate secretary, or whatever who your contact is?
It could vary. I'm not prepared to say yes or no to that. I thought that they did.
Particularly with managers. I mean, it might be in your operating agreement, but you don't
Right.
have to post that on the internet, I don't think, do you?
Yeah, but I'm not suggesting that's an obligation for patients. I'm simply saying there is a public record of it, but the
But it
problem,
seems like that would be the end result.
well, the end
I don't
result
even know
is-
that there'd be a public record of it, is my point. You'd have to have a subpoena or something, or have some type of ability. I mean, let's assume there's no way for people to know.
Okay.
Then what, the legislature just, they botched this? Because obviously they didn't intend to have people, have a private investigator with them every time they would go to the doctor's office, right?
Right. Well, there's still this old case out there from 1995, Wambach, that says if you're sued directly for the provider and you believe it's covered or no fault, you'd be indemnified. So I suppose the carrier would have to come defend them from that suit. But I think more importantly, if you got services that are being provided that they're without the licensure. And I'm going to get back to Justice Zara's hypothetical because it came up in plaintiff's counsel's presentation, and I want to clarify something. But if you're getting services from somebody that's not licensed and they come after you for payment, you're going to have defenses to payment. It's going to be, the contract's going to be void for illegality or for a number of other things. So I think that's a problem we can set aside. I think big picture, the hope isn't necessarily that these patients are going to be stuck with a bill, but that these entities will clean house. And because right now it's too easy. The reality is these are mostly direct, they're suing the carriers. These aren't bills being presented by a patient, they're being presented by providers, and it's too easy to just stick it to the no-fault carrier, knowing that there's no inquiry, there's no ability to inquire into these corporate issues, which in this case touches on the licensing issue that I think is very important under the PLLC Act and the Public Health Code. Might have lost sight of your question. I apologize. Justice Welch.
I think I'm all set, thanks.
So then there was one time when I'm out of time, so I won't feel bad if you cut me off at any point, but
I'm going to cut you off.
Justice Zara's hypothetical
I'm going to
was-
cut you off. The case will be submitted. Thank you both.
Okay.
Appreciate it.